Okay, welcome everyone to the network series. This is a group of SESPs, graduates of PCTI, and CPAC, MassPAC, so members of MassPAC. And our hope is that when we get together that we'll learn something from our guests, but also that you guys will get to know each other and network afterwards. So today we have Tim Sindelar with us. We're very lucky to have him. I think a lot of you have already seen him speak at PCTI. He's in private practice in Newton, and his practice chiefly focuses on special education and other litigation that concerns the rights of children to essential services like education and healthcare. Let me know if I say anything that's inaccurate.
You got it.
Before he went into private practice, he was a senior staff attorney at the Disability Law Center in Boston, and he also worked for more than 15 years in legal services programs here in Massachusetts and also in other states. Tim has represented people in matters before the BSEA and the state and federal courts on special education issues. He's also worked with parents groups on legislative and regulatory issues pertaining to special education, and he's served on a number of advisory groups. He frequently presents for the Federation, which we very much appreciate, and we certainly consider him a friend of our program. So please welcome Tim.
Thank you.
So today's program is a Q&A on manifestation determinations, and I gathered some questions from some of you and people who couldn't be here ahead of time, but also we welcome interaction from the group. So please keep your questions generic so they'll be interesting to a large number of people. Don't ask super specific things that won't apply to anyone else. That's okay. And silence your phones. Can you just discuss under what circumstances one of us might be asked to attend a manifestation determination? So an SESP or an advocate or someone from a PAC.
Sure, I'll try to. You know, discipline matters come up fairly quickly, and it's often difficult to get to an attorney quickly. The issues presented in a manifestation meeting, actually, and in terms of general discipline hearings as well, are, I think, fairly discrete, manageable issues that lend themselves well to the advocacy that can be done by properly trained, I hate to use the word laypersons, but non-attorneys. So, I mean, I think that is a great thing for people to be doing. You know, manifestation meetings are required when there's going to be a change of placement due to discipline. It's the easiest way to say it. The regulations, I mean, you know, the federal regulations in general are torturous to read, but the regulations around manifestation are really difficult, I think, in the way in the language it's used. And part of that is that they're a product of you know, a 30-year tug of war back and forth. I mean, I think the most difficult area about IDEA in terms of the legislative process has been around discipline. And every time that there's a reauthorization, there's a tug of war one way or another around the manifestation provisions in IDEA. And where we are right now is the result of being on the losing side from a parent's perspective during the last reauthorization now 14 years ago, 15 years ago. So the language is torturous, but to get back to the point, you know, it basically says you get a manifestation when there's going to be a change of placement. Then it goes on to define change of placement as being out 10 days or more from a placement. And so then the big question becomes, well, how do you count those 10 days? And it used to be pretty easy because way back in the ancient days when dinosaurs roamed the earth, we had state regulations about discipline in our state special education regulations. Those all disappeared in 2002 when there was a cleansing, when we went from 90 pages of regulation down to about 35 pages, depending upon what font you use, of course. But and all state regulations with regard to discipline disappear. So, you know, you can pull up the state regs and you won't find anything in the state special education regulations of any substance with regard to discipline. when we had the state regulations said 10 cumulative days. And then there was always a question, well, cumulative what? In a school year, in an IEP period? And there was debate about that. And some people took the position in an IEP period, some in a school year, but at least we were knowing that we were talking about 10 cumulative days. Well, those regulations went away, and fortunately, a lot of people don't pay attention to changes like that. And for a long time, everybody kind of thought it was 10 cumulative days, 10 cumulative days, and never had any issue about it until about 2 or 3 years ago. And a couple of the attorneys on the school side started paying attention to the fact that those state regulations no longer existed, so he turned to the federal regulations. The federal regulations say it is consecutive or a pattern. Okay, what's a pattern? Well, we can look at OCR decisions about pattern, and actually we have now some BSEA cases that kind of talk about it too. But there's still a lot of debate about what it means to be a pattern. Does it have to be the same kind of offense? Does it have to be within a relatively short period of time? Can you have a suspension in September for fighting, and a suspension in October for smoking, and a suspension in December for skipping school? Is that a pattern? Well, probably not, other than they're suspensions, and they're coming fairly frequently. But it gives us something to talk about. Most schools continue to apply the cumulative rule. And there's another reason for applying the cumulative rule, because when we did our general education discipline reform about 5 years ago now, the state, fortunately, in the legislative process, adopted the cumulative standard in terms of counting to 10, because 10 becomes a significant number in general education discipline in terms of what a hearing looks like for something under 10 days and something over 10 days. And it also is important with regard to the right to continuing educational opportunities, less than 10 and more than 10. So hopefully you won't have to come up with that question, but more and more I'm getting school districts pushing back saying, no, it's not 10 cumulative days, it's 10 consecutive days. So we're not going to do it until it looks like that. And then there becomes the timing issue, which is, again, a very confusing point, and I've heard debates on both sides of it. What comes first, the decision to discipline for more than 10 days, or the decision, the manifestation determination? And again, my experience for many years was most school districts decided to do manifestation determinations first. Partly it made sense because it was a way to save time. If a manifestation determination was resolved favorably for a student, then there was no need to hold the discipline hearing because it couldn't discipline the student. So it just made sense. Do the manifestation, have one less meeting, one less hearing. But again, I saw a shift about 3 or 4 years ago, and many school districts have been looking at the regulations, and the regulations says something like, within 10 days after it's determined that they will change the placement for 10 days or more. So it kind of suggests that manifestation comes after the discipline determination. In addition, I've had school districts lately say, we know that we may not be able to discipline this student, but we want to have a record that we had a hearing and we took it seriously, and we want to be able to have it in the discipline record that we found the student committed this offense. And so we're going to do the discipline hearing first and then the manifestation. Again, there isn't probably a clear answer in the law about this. I think that the way that the regulations are written, it probably favors the interpretation, discipline first, manifestation second, in terms of the process. But you could look at it in either way. What most school districts do these days, in my experience, is they'll schedule the discipline hearing with the principal or the principal's designee at 10 o'clock in the morning. and they'll schedule the manifestation for 11 o'clock in the morning. And that's fine. It tends to work. So that's kind of the timing about when you might get pulled in to do it and why you might get pulled in to do it, because again, getting to attorneys is kind of sometimes arduous. Let me put a little plug in though for those of you who are SESPs. You know, there's this kind of secret in a way that, you know, DCF has a contract with, there are three of us, three attorneys, to provide assistance to kids in DCF custody. And a focus of that representation for the last, well, since we did the discipline reform 5 years ago, has been discipline matters. So if you are an SESP and you've got a discipline matter, including a manifestation, I would recommend that you have the social worker talk to the ed coordinator, then run it into central and get approval and get an attorney to come to the meetings. It's not that you absolutely need an attorney, but I think that, you know, it's a resource that you should take advantage of when you can. Is that a long answer to that short question?
That's fantastic. Do you want to follow up?
I just have a question for you. So you said, did you say there were 3 attorneys that normally do?
There are 3 attorneys that DCF has a contract with in the state. Myself, Matthew Engel, and Tom Schiavone. No, not Dan. So,
What did it, so what they need to get?
Myself, Matthew Engel, who's out in East Hampton, and Tom Schiavone, who's in Lynn.
Okay, thank you.
Mm-hmm. Yeah. He's not really doing many, so I don't think you'll ever see him. But he's a guy, he was there at the beginning. You know, he was there pre-766, one of the dinosaurs.
Can you describe what we would expect to see in an actual meeting?
Yeah, I'll try. I'll tell you what the regulations say, and then I'll try and say what my experience has been. You know, and when I say my experience, I have never sat down to count, but I would say probably, you know, someplace between 30 and 50 manifestation meetings. You know, I may do 2 or 3 a year, just depending upon how things kind of flow. But the regulations say, first of all, it's a team meeting. It's a kind of specialized team meeting. So the regs say that it has to be attended by relevant team members. Then it doesn't define what relevant team members are. So, you know, what we kind of think is, well, it probably means that you don't have to have the speech language therapist there unless there's some issue directly related to the speech language therapy or the need for it or communication or something like that. And I would suggest that if you feel that there is a particular team member that's needed, that you communicate early on with the school that you would expect that so-and-so will be there. But so the regs don't give us much guidance beyond relevant members. They then tell us that at the meeting, the team that's present is supposed to review some information, and the regs define what that information is. IEPs, behavior plans, evaluations, data, and any information that the parent brings to the meeting for the team to consider. Now, I've been to a lot of these meetings, and it's rare that there's any concerted effort to actually review things. And so a lot of times, you know, I mean, people want to jump into the questions, and I've kind of have to say, well, let's get a base before we jump into the questions. Let's talk about, you know, what's the disability identified, what the behavior plan is, if there is any, all of these things. Let's at least do kind of a review so everybody in the room is on the same page with regard to this individual. In addition, on this question of information that the parent brings in, I've had several times that this happened where I may have a student who has been identified as a student with a specific learning disability in language, i.e. dyslexia, and so is receiving language-based services of some kind or another. And that's what's driving the IEP, and that's the main, maybe only service on the IEP. But somehow since the last reevaluation, as is often the case, symptoms of executive functioning become pretty clear with regard to this student. And the parents have gone out and gotten a private evaluation, or maybe not a neuro, but have seen the pediatrician, and the pediatrician is prescribing medication or has definitely, determined that there's ADHD. And so when it gets time for the manifestation, the parents bring in a report saying ADHD, here's some of the symptoms, blah, blah, blah. And I've had school districts say, we're not going to look at that because the disability on the IEP is dyslexia. To which I say, regulation says you look at all information submitted by parent. Period. End of discussion. And usually they, at that point, will acknowledge that they need to do that. And in fact, there are a couple of BSEA decisions where there have been appeals of manifestation, and the reversal of the manifestation determination has been premised largely on the fact that the school district hasn't reviewed relevant material as part of the process.
Is the legal standard still they have to consider it?
Yeah, it's consider, or but at least there has to be some indication that they've done that. And when there is nothing to document that they've done that, and it gets up to the BSA, the hearing officers tend to say, you didn't do this, we're reversing it. At least there have been a couple cases that have been driven by that. So, so what happens? Again, there's this review of information, and then, we get to the guts, what the central questions that are driving the manifestation. And this has always been a problem. It's gotten clearer. I mean, I think finally almost every school district has caught on. But for a long time, they were stumbling with it because those questions changed over the years. As I say, this has been a legislative football, and again, school districts are kind of slow to catch on sometimes. We tend to do the same thing over and over again, the same way we've always done it. But I think, since the current questions have been in effect for more than 15 years, I think almost everybody now understands them. At least kind of understands them. I mean, so most school districts now come to these manifestation meetings with a script. And the script is, why we're here, what we're going to do, let's look at the information, and then it's, okay, here are the questions we have. And I've been to many meetings in the last couple of years where, school districts have been well trained by their attorneys, apparently, and they're putting these kind of little ballots out. I mean, here's the 2 questions, check yes or no to the 2 questions. So, there's a varying degree of organization, but I'm seeing more and more. So, the 2 questions. The first question is the most important for almost all of the cases, and that is the student's conduct that gave rise to these proceedings directly and substantially related to the student's disability. That's question number 1. And question number 2, was the student's conduct that gave rise to these proceedings a direct result of a failure to implement the IEP? So, they're kind of limited questions. Let's take the first one, because most of the cases tend to be about that. What does it mean to be directly and substantially related? All I can tell you is that it's kind of in the eye of the beholder a lot. I mean, it's great when it's great when you have the kid with Tourette's who's being disciplined for swearing. Boy, I love those cases. We don't get those cases because everyone understands that's a direct manifestation. But as you move away from that and things become more and more attenuated, where do you go? I mean, obviously, with executive functioning limitations, impulsivity, difficulty planning, almost anything can fit within the parameters of that, and it becomes kind of a question of, a tug of war about, well, does it really? A lot of, let's take, you have a student who brings an item to school that shouldn't be there. but not a weapon and not drugs, something else, okay? Because drugs and weapons, you know, in a separate category by themselves. But so a lot of times, you know, this will happen, or it'll happen with a weapon. I mean, you know, I had so many times the kid forgets that the knife's in the backpack because he went camping the weekend before with the Boy Scouts and used that backpack, and, you know, and the knife's there. And so the students' lack of planning, their students, you know, lack of memory about it there, you know, are those directly and substantially related? And, you know, and I think sometimes, you know, you're successful in getting the team to do that, and to agree to it. Yeah, and sometimes you're not. And we'll talk a little bit about the evidence that you can develop around those questions. One of the things that the schools like to say is he knew what he was doing, okay? And I keep saying, that's not the question. The question doesn't say didn't know what he was doing. The question isn't a not guilty by reason of insanity. That's not the way it's phrased. I mean, it's similarly related in style. We don't punish people who do things because of their disability. So we don't punish people criminally if they meet the standard or not. And there, you know, these issues about what they understand and all that get more tied up, but it's also more scientific, professional opinion things. In this case, you know, again, we let a bunch of amateurs kind of feel out and make these determinations. But it's not that he knew right from wrong. He was planning, you know, he understands it. He acknowledged he was wrong. That's the other one I always like, you know, we caught him with it and he said, yeah, I'm wrong. I shouldn't have done that. It doesn't mean that it still isn't a manifestation, that it isn't directly and substantially related. But a lot of times they use those types of arguments around that question. Let me skip to the second question. And the second question, you know, it's helpful to give you a little history. Before this change, the last time that the law was reauthorized, the question was phrased differently. And the question was simply, had the school failed to implement the IEP fully? Just that. I loved it. You know, I would have, because, you know, you would always have a speech language therapist who went out on maternity leave, and you missed 3 sessions of speech language therapy during the IEP period, and the kid brought a bag of pot as a result of that to the, you know, to school. Well, I didn't have to say as a result of it, you know, before, you know, it was just you didn't comply with the IEP, automatic manifestation, you know, don't have to worry about it. Now I have to show that it was caused by the fact that you didn't get a speech language therapy. And believe me, you can get pretty creative, but not that creative. So, and again, pot's a whole different thing. Should never use that example because, you know, weapons, pot, assault on school personnel, doesn't make any difference whether it's a manifestation or not. They can still be sent to 45-day interim alternative educational programs for those offenses. So, you know, I got to tell you, when I have a case involving those items these days, I used to say, we'll waive the manifestation because it doesn't really make a difference. Let's just talk about what we're going to do and move forward to that next step. I don't know if that triggers a question. I mean, I can go on. Go ahead.
I have a question. So if a child has a disability and their behavior is due to the disability, very common with it, and the school basically fails to notify the parent of an FBA assessment, and they just react by putting DCF on the child, is that a matter of manifestation?
Well, no, because calling DCF.
Did you hear the
Yeah,
question?
I'm sorry. I'll repeat the question for the listeners at home. The question is that if instead of imposing discipline, a school district gets DCF involved with a student whose conduct that they're having a problem with, is that related to a manifestation? And And the answer is no, it's not. I mean, a manifestation is solely about a change in placement, changing the educational placement for more than 10 days. I mean, that's what triggers it. You know, anything short of that doesn't require manifestation. Now, I do see a lot of school districts these days holding a manifestation after there has been some kind of serious offense, even if they're not thinking of a 10-day sanction for the student or some kind of change in placement. And you know, when I ask why, they kind of say, well, we like to be on top of these things. We like to be proactive. And I think that part of it is because, you know, one of the things that comes out of manifestation, I mean, if it's determined that you meet either of those two questions that we just talked about, the school cannot punish you. But number two, they have to do an FBA if they haven't done an FBA. And if they've done an FBA and there's a behavior improvement plan, they have to review the plan to say, why isn't it working? I mean, we're here again because of discipline. What's wrong with the behavior plan? And they have to adjust it. So schools often kind of use the manifestation process to jumpstart, kickstart that process and get it going. But, you know, in terms of doing other things like involving DCF, involving the police, those aren't things that require manifestation determination. One of the cases, I just dumped a whole bunch of cases. I don't know, did you copy all of those or?
Yeah.
Okay. I went through and picked 7 or 8 of cases out of the BSEA about manifestations. And one of the really interesting one is a case out of Taunton. The student's name is listed as Adam. And there are actually 2 decisions involving that case. It's really, it's one of those nightmare situations, but it's one where the student was suspended from school for more than 10 days, and they never had a manifestation determination.
Does anyone need this?
So, and the student was out of school for a year. And then the parent, you know, found somebody to help them, and actually they did this pro se on their own, no attorney, and took it to the Bureau, and the Bureau looked at it and said, huh, you bet. You know, this is wrong, this is a violation, and it got a hold of manifestation, and the student goes back to school today. You know, they had a expedited hearing on it, and the student went back to school. That was part of what the parent brought forward. In addition, they brought forward claims saying, okay, you know, the school failed to follow IDEA, they therefore violated Section 504, and they violated Section 504 in doing other things, like getting DCF involved in the picture, like kicking the kids out of ROTC, and I can't remember all the other things, but there were a number of things. So there are 2 opinions in this case. One of them is about the failure to hold a manifestation, and then the other is about all these other claims. And in all the other claims, the hearing officer found that none of those other things were violations of anything. So, you know, other than the fact that the student was improperly excluded from school, she found that was in fact a Section 504 violation, and that's it. I mean, she didn't order any relief because the BSEA is not very good about figuring out relief in any cases except for the kind of the black and white, either, you know, have a school district reimburse the parents for the cost of something, or, you know, make a placement. When it gets beyond that, they kind of throw up their hands usually, and the general way that the BSEA hearing officers respond to like claims for compensatory services. I mean, let's say you had a case in which, you know, among other issues, there was the fact that 100 hours of ABA services weren't provided. What's the BSEA going to do about it? They're going to say, yep, that's a violation, and we're going to order the team to meet to figure out a way to make up those hours. And the same kind of result here. I mean, the student got back into school. The parent got a favorable decision, but there wasn't a lot of relief ordered. And I just, I kind of brought this up because of your question about DCF involvement and things. What's even worse than DCF involvement is police involvement. And let me just mention that. I mean, it's not technically, manifestation stuff, but the interplay between discipline and police involvement is really an interesting thing. Tony DeMarco, I don't know if you know Tony. Tony's a children's attorney. He actually founded the Children's Law Center in Lynn. Fabulous guy, really smart. Had a case that he took to the Office of Civil Rights out of Lynn. That was really interesting. And as best as I can summarize the principal points, he's representing this high school student who was having lots of issues, had some real social, emotional things going on, was kind of in and out of discipline stuff with the school, but at one point was in a discipline meeting with the principal, and they had the school resource officer there in the discipline meeting. And she got upset and picked up a spray bottle with water in it and sprayed the principal. School resource officer didn't laugh, threw her to the ground, handcuffed her, and took her off to the police station and charged her with assault and battery. Okay, so Tony worked on that. He went to OCR. 3 years after filing an OCR said, "Yep, that was wrong. They shouldn't have the school resource officer at ordinary discipline meetings. If there is like some kind of really unusual thing, or if the school resource officer was a witness or somehow, but you shouldn't have the school resource officer shouldn't be involved in team processes. You shouldn't do that." And they ordered actually a bunch of relief, and the student got some summer programming, some extended programming, and things out of that ultimately. And it was a really good OCR decision. About the same time, the Attorney General's office was advising school districts about the memorandums of understanding that they have with police departments around school resource officers. They all have these MOUs that describe what the relationship is between the school district and the police department around the school resource officer. And Maura Healy got involved in this process, or people in her office, and suggested a lot of improvements to the memorandum of understanding, including things like, there ought to be some exercise of discretion as to who gets to become a school resource officer. They ought to be people that like working with teenagers and, things like that. But it also suggested, that the, school resource officers aren't to be involved in team processes, aren't to be involved in discipline. I represented a student in a rural Worcester County school district where every time something happened at the school, 2 police cars from the small town police department would show up, and the police officers would walk the halls, and it was just a real display of police power present there. That's since stopped, but yeah.
So what weight does that Attorney General opinion carry? Because all of these MOUs are written at the local level.
Well, they're not. See, she proposed a model MOU.
But it hasn't come forward. There's still local MOUs in place with respect to SROs.
Well, they were supposedly supposed to, as part of this advisory process, re-adopt new MOUs based upon the model.
Okay, so all of us as parents or leaders in our community should take a look at that local
That's
MOU.
Right. Yep.
And if there is a role for SROs in team meetings, that's something that as parents and leaders in the community, you should have dialogue about to take that out.
That's correct.
Okay.
Yeah. And I think that you might be able to get some help from Maura Healy's office.
Yeah, that's a great idea. I didn't know that.
Yeah. So I don't know, long answer to your short question, but it led me to think about a lot of different things. The question is, again, clarifying what triggers a manifestation in terms of 10. How do we count to 10? Whether it's 10 consecutive days or 10 cumulative days. And I'm not sure that I can really clarify it much, but let me try.
Excuse me, does it have to be the 10 or a pattern?
Well,
That's really what I'm-
yeah. A pattern of less than 10 days is not going to meet it ever.
No.
Okay, so 10 is a threshold, and it's a matter of counting to 10. And whether we count to 10 by the school saying you're going to be out of school for 11 days, that's easy. Okay, but if what we're talking about is a pattern of short-term suspensions, 2 or 3 days over a course of a school year, you know, usually most school districts, when we get to 10, you know, so you've got a suspension for 2 days in September, you've got 3 days in October, you've got 3 days in November. In December, they're looking at the possibility of imposing a sanction of 3 days or more. In that case, you know, most of us would take the view that that is a pattern and that the school district should hold a manifestation before excluding that student for that 10th day.
Do you include internal suspensions or parent having to go pick up the child?
Yeah, so the question is, do you include in counting 10 internal suspensions and the parent being called to pick up the child? The second part, yes. I mean, if the student is excluded from the school for any significant part of the day, it should count towards the 10 days. I think that the State Department, PRS, has been looking at this, and I think that they think a half day or more. So if the student's excluded at 2 o'clock in the afternoon, they probably don't count that as a day of suspension. And from common sense, that probably makes sense. But if it's before halfway through the day, then they're going to count that as a full day of suspension. And let me just put a little caveat to this. That should not be happening, okay? We all know that. It still happens. It shouldn't be happening, but, you know, to the extent that we can arm the parents we work with, you know, the ammunition about it, that's important. And I will say this. Schools have gotten kind of wise about the new disciplinary provisions and have figured out the easy way around them. And the easy way around them is this. I mean, you say, you know, the way that our state general education disciplinary statute reads is a student can't be excluded from school until there's been something. Let's call it a meeting. You know, we can call it a hearing, we can call it whatever, but let's say a meeting. That is probably less inflammatory, with the principal or the principal's designee. A student should never be excluded from school, no matter how much time, without that happening, except for this very narrow emergency category that the state's created. The State Department of Elementary and Secondary Education has created. It's not in the legislation. Won't go into that, but so what schools tend to do is this. They pick up the phone, they call mom, and they say, come in and we want to see to you about Joey's in trouble. Joey hit Jimmy, come on in. So you go in, and parent doesn't know what's happening, and they sit down and they meet with the assistant principal who's charged in discipline. They say, you know, we had to take Joey out of class. He's here. He hit Jimmy. We'll get back to you about what we're going to do further. And the schools call that the meeting that's required by state law. It's probably not if they haven't been provided written notice in advance. So schools have figured that out. So now what they do is they have these form notices ready to go, and they email them to the parent while the parent's driving en route to come pick Jimmy or Joey up. I recently did have PRS uphold, well, I challenged a suspension where the parent hadn't received any written notice. They had been told, come in tomorrow and talk to us about it, and they came in the next day and they had a full-fledged hearing, but they hadn't been advised what the charges were, who the witnesses were going to be, anything like that. And PRS said that was wrong, and the school's got to take action to fix that. But again, that's a deviation from your just from the counting picking kids up, but generally we're going to count picking kids up one way or another, whether it's in compliance with the general ed disciplinary process or not.
One more to ask about that?
Yeah.
Having to go get your kid because he's not allowed on the bus.
So there are some case decisions about buses, and they kind of come down to this. If the student can't get to school because they are suspended from the bus, then a bus suspension counts as a suspension from school. But if the parent's able to take the kid to school, and does, then of course it's not a suspension. So coming to pick them up because the kid can't ride it, a school could determine that, especially going home. Going home is never going to be a suspension from school, but coming in the morning could be. There was a second part to your question. So do we count in-school suspensions? Right. And the answer about in-school suspensions is maybe. It depends upon what happens during the in-school suspension. If the in-school suspension is the classic Bart writing on the blackboard, I will not set fire to the wastebasket again, then it's a suspension and it counts. But if instead of Bart writing on the board, Bart's given the worksheets from his math class and told to do the worksheets in the principal's closet or wherever, it's not a suspension. They're still receiving services. They're still in school. So that doesn't count.
But does it count in a sense as well against their record that they're internally suspended then, if they're still doing work?
If they're still doing work, they're not regarded as internally suspended for IDEA purposes. They are regarded as internally suspended for state general education purposes, which is weird. But at least that's what I've seen around IDEA stuff. So we're counting to 10, and again on the pattern stuff. Like I say, we're always going to be. It's always going to be 10, and the clear part is if the school is considering having the student out for more than 10 days at a time. If it's something less than that, if there has been a pattern of suspensions, and all I can say is that there's a variety of mostly OCR decisions around this point. These cases don't get to hearing very often, so we don't have those to look at, but around the pattern stuff, OCR has found patterns with all kinds of combinations that get to 10. And found in other cases it wasn't a pattern. So there isn't really a clear way to define it. My recommendation is that you always argue that it's a pattern and get the school to do it, and at least it gets them to think about it. It preserves the issue. If they don't have a manifestation, you could go to PRS about it. You can go to the Bureau about it. You can preserve it. It might be something in your pocket if you have to do something else at the Bureau. But ask for it, because if you don't ask for it, then they might just say, oh, you waived it, and nobody cared. I got it. So, ultimately, the question comes down to what kind of paperwork does the district have to provide?
Want it in writing when we leave.
Right. And, but, along the way, you talked about, going beyond just the manifestation questions and talking about placement. So, I start with the principle that the regulations say this is a team meeting. Mm-hmm. And so other regulations that apply to team meetings apply to these meetings, which means that PWN applies to these meetings. PWN, prior written notice, which is more of an art in other states than it is here. But, it still basically comes down to this. If you ask the district to do X and they say, no, we won't do X, that they have to put something in writing saying, we had a meeting, you asked to do X, and we refused to do X. And that would apply also to the second part, or to any part of the process. So they should be documenting manifestation meetings with N1 forms that say, we met, we had a, do they? I've never seen one. And, you know,
We did get the district to do that, but as in terms of the manifestation itself, documentation, does the parent have any right to leave that meeting with notes, a copy of anything?
well, again, I mean, you know, at least under our, you know, state advisories, you know, we've got Marty Mitnock's confusing directive that says, what, something to the effect that if they give you minutes at the meeting and a grid, then it satisfies their obligation to get an IEP out instantly. You don't have to do anything for at least 10 days. But it doesn't really say that they have to give you minutes or a grid, but that it's one way to get more time rather than have to issue an IEP immediately. Or 3 to 5 days or whatever we've interpreted immediate to be. So I guess I'm just kind of, you know, working through this in my mind. Is there a requirement that they issue you a summary or something at the end of the meeting? No, I can't point to one, but again, good advocacy, you know, if it's important to you, and it's probably important to all of us, I mean, in terms of having documentation with regard to this, is then to follow up the meeting with a letter saying, here's my understanding what happened, you know, and if your understanding is any different, please correct. So the question is, schools that exclude students, ask students to be picked up by their parents because in the school's mind they're manifesting some kind of health problem, but the parent has the student examined and finds out that that's not the case, but the school does this repeatedly. You know, it doesn't, again, it's not, I suppose if there were 10 days of that, and you know, one could say, I need a manifestation before you do this again, but you know, because it does become a change of placement again if you hit that 10 days. So you know, you could require that there be a manifestation, but I think that way before that, you know, the 4th or 5th time that happened, I would be asking the school to hold a team meeting to discuss the issues and to formulate a health plan, if nothing else, to address these concerns. And bringing into the school, you know, documentation for the child's health care provider about any health issues, if any, and that recommendations from that part, and then trying to develop a plan. I mean, I assume that the school is sending the student to the nurse.
Yes, and basically, the parent asked for a record of all the days that the child had to be picked up, and the nurse only provided one, which was incorrect.
So the nurse's own records weren't good. But beyond the nurse's records, I mean, the school must have some kind of records with regard to the school's attendance, the student's attendance. And then it's a matter of not going to the nurse, but going to the principal and asking for the attendance record and noting what days the student's been excused on or something. Would be one way of dealing with that issue. I mean, and, you know, and nurses, I mean, you know, we often forget that, you know, there are these health records maintained by nurses. And, you know, and generally when I'm doing advocacy involving a student, you know, if I'm getting involved in some serious issues, you know, I ask for student records. And one thing I make clear that I ask for is not just the temporary and permanent files, as the statutes refer to them, but also the health records. And so those usually arrive in a separate envelope because they feel that they've got to comply with HIPAA, although they probably don't. But you know, it's always kind of good to see what's there. And then, you know, you may have to actually physically go to the nurse's office to see. And maybe she's just a poor record keeper. I don't know.
Thank you.
Sure. You know, I wanted to get back to the question about what happens after the resolving these two questions. you know, because your question before talked about placements and stuff, and I think that we should talk a little bit about that. So again, going back, we've got these two questions. If the answer to either of them is yes, the student can't be disciplined for the conduct, and the student goes back into their same placement, and the school does an FBA. But the regulations say unless the parents and the school otherwise agree. And so oftentimes, you know, a manifestation meeting does lead to a discussion of, is the current educational placement appropriate? And 9 times out of 10, in my experience, what that leads to is a suggestion of an extended evaluation. Almost always a major disciplinary incident will lead to a discussion about extended evaluations. And it's kind of interesting to me. So we have extended evaluations, which are a creature of the Massachusetts regulations. You won't find them in federal regulations. There isn't any reference at all. They are purely a state thing. And we used to call them something different under those old regulations, and they were slightly, the regulation was a little bit different. But, you know, again, essentially an extended evaluation is letting the school district have more time to do something vague that we might call an evaluation. But it doesn't, I mean, a lot of people say, oh, it's an evaluation, so we're going to get, you know, a psychological assessment, we're going to get academics, and we're going to, that isn't anywhere necessarily true. I mean, extended evaluation just kind of creates this framework. I mean, a lot of times, let's say a school district has failed to do an evaluation within 30 school working days, and when the parent signs the consent, you'll see school districts say, oh, well, let's just do an extended evaluation. We'll do that speech therapy evaluation and an extended evaluation, which really is probably a misuse of the form, but that's one of the things they do. But aside from that, what we generally do with extended evaluations these days is use them as, quote, trial placements. And so, you know, we now, I mean, almost all of the collaboratives and many of the private special education schools run extended evaluation programs. We'll take your student in for 8 weeks and see how they do. And so there's a form for that, you know, and this team is supposed to say, well, what is it that we want to get out of this? You're supposed to have questions that you want addressed by the extended evaluation. There's a suggestion usually that you meet halfway through or some point before the and then you have a meeting towards the end of the extended evaluation to review that extended evaluation. So again, that often ends up with the student being placed into one of these programs. There is always a lot of confusion about this being a 45-day placement. It's not a 45-day placement, and the state's made that pretty clear. It's an 8-week placement, which 8 times 5 is 40 days. And that's all the state regulation allows. But damn it, people can't get 45 days out of their mind. And part of the reason they can't get 45 days out of their mind is because the special education regulations allow placement in IAESs, interim alternative educational settings, for 45 days, calendar days. No, I'm sorry, school days. So for 9 weeks. So there's, people get those ideas mixed up. And because, you know, one of the things that could come out of a manifestation meeting is that they could find that it was not a manifestation. The student could be punished, and the way they're going to do it is by put the student in an IAES for 45 days. Now, where do you go for an IAES? Collaboratives, private special education schools. Do they look different than the extended evaluation programs? No, for the most part. I mean, some places they do. I mean, you know, Boston, Worcester, maybe Springfield, run, Brockton. They all run schools that are for kids that are out there because of discipline. And so those are a little bit different than extended evaluations, but I've seen those settings being used for extended evaluations too. But you know, that is the possible result of a manifestation if you lose it. And even if you win it, if it's drugs, weapons, or assault on, I'm sorry. assault that meets the standard, I'm going to blank on the term, of serious bodily harm. And that's an interesting thing. So serious bodily harm is defined in the federal IDEA statute to refer to actually a federal criminal law. And I mean, I wish I had the definition here, but it's something that involves maiming, serious disfigurement, possible loss of life. It is not, as I say, it's not biting, or the common one that I like to see is kicking the teacher in the shins.
Oh, yeah.
You know, I mean, that's not going to be serious bodily injury by the definition of the statute. But again, a lot of people don't read the footnotes to get to there in terms of schools, and so sometimes you have to fight about that. So the question has to do with challenging both a hearing determination and how a manifestation might affect it. And it shouldn't affect it. I mean, you know, again, all students, whether the general ed or regular ed student, or general ed or special education students, have these rights that are set forth by the state law in terms of the disciplinary process. And those are parallel, or, you know, somehow another track, as opposed to the additional protections of special education law. So you could certainly go down that route. I mean, and you should. I mean, I often do. I you know, do the regular education discipline hearing. I do the appeal. At the same time, I'm trying to win the manifestation and trying to resolve things. Yep, absolutely.
The one resolves in your favor.
Right. Yeah. I mean, you know, sometimes it involves a little tap dancing because, you know, if sometimes there's a fight about the facts. Jimmy and Joey got into a fight. Who threw the first punch? Who was the aggressor? Who was, you know, more significant? Now, I mean, most schools have these policies that we don't care who was. You know, we're going to punish them both equally. They shouldn't be punishing them both equally because that's contrary to both the state and federal law at this point. But at any rate, sometimes there's that fight in the general education proceeding. Manifestation just kind of presumes, assuming Jimmy did this, okay? You know, it's not a fight about whether Jimmy did it or not. We just kind of make this assumption, was it directly and substantially related? But you can do that. What makes it really difficult is when you have possible criminal charges pending about these things, because at that point, it becomes very important that Jimmy not testify, because anything Jimmy says can be used against him in the criminal world. And hopefully, I mean, if there's any chance of that, you know, hopefully there's some there's just some counsel available. You know, and it becomes complicated because, you know, a lot of times kids don't get to get an attorney appointed for them in the juvenile court process until they're arraigned. And so you might have the school stuff happening before you get to that point in the juvenile court world, and you kind of have to walk back and forth. My experience has been, you know, CPCS has this youth advocacy division, and they run the educational law task force. That's not exactly right. It's not that they run it, but at any rate, they have they also have an entity called the Ed Law Project, and they will often step in and provide some assistance. They can usually get an experienced juvenile court attorney to help advise the student in that process even before arraignment, if somebody goes to them and says, I need some help in that direction. But you know, you do have to be aware that there are these different competing considerations in those situations. The question is there differences to who's assaulted? So in our state general discipline law, we have a separate category for certain kinds of offenses. Drugs, weapons, and assault on school personnel. So that determines the kind of avenue that you go down for the general education discipline. That's a little bit different than the other two branches of general discipline. Got you confused yet? I hope so. So that's why it becomes relevant. But then, I mean, there are all these kind of parallels that exist. So in IDEA, with regard to manifestation, I mentioned before that there are these exceptions to the rule that you can't punish if it was a manifestation of a disability. And the exceptions are drugs, weapons, and serious bodily injury. But with IDEA, it's a serious bodily injury to anybody, not just the school personnel. You know, usually there's not a conflict between those provisions, but it just, you know, you get confused. In addition, just to throw it out, make life even more complicated, weapons under state law, weapons can be almost anything, okay? There's no explicit definition, so the courts refer to common law definitions, and common law definitions coming from criminal law, which means almost anything can become a weapon. And in fact, you know, the classic one that we probably all know about is the person charged with assault with a dangerous weapon, to wit, a shod foot. Okay, that's under the state law. Under the federal law, under IDEA, again, interestingly enough, when they put the weapons thing into the law, they took this shortcut of saying, okay, we're going to use the federal definition of weapons from the federal prisons. There's this law that makes it a felony to bring weapons into federal prisons, and it defines what a weapon is. With regard to a knife, in order for it to be a weapon, it has to have a blade of more than 2 inches. Under state law, that's not the case. So we've got this famous case. Well, at least it was famous to me because I was in Worcester at the time and worked on the case a little bit. But it's the Parkins case. And in Parkins, this high school student had what the court referred to as a novelty item. And it was a little lipstick container that had a razor blade type point in it. You know, as you twist the bottom of it, the point came out, and that point came out, I think, maybe 1/4 of an inch over the thing. Well, Parkins was excluded from school for the rest of her life for possession of that device, which would not have qualified as a weapon under IDEA. Yes.
I just want to say I had a student suspended for maybe 2-inch long plastic clear orange water gun.
Yes, the water guns are an interesting point, and there is actually, I believe, pending in the legislature at this time. There are a number of bills to tweak the disciplinary process a little bit, and I think one of the things they're trying to do is exclude facsimiles, at least for kids under a certain age, because it makes no sense. But that does lead, though, to the one of the cases that I brought with me is, I believe this is the Westford case. And in this particular case, if I remember correctly, the student got mad at a teacher who was having an altercation with the teacher, the student with a disability. And at some point, students started pulling on the teacher's tie. And the teacher got red, and it hurt a lot, and it was a problem. And so they suspended this kid for use of a weapon.
Yeah.
The BSA had no problem at all saying a tie is not a weapon for purposes of that discussion. But let me throw things out again to make it confusing, because again, we've got these two parallel tracks. You've got general education discipline, and we've got manifestation, special education discipline considerations. The general education determination as to whether or not the student violated provisions of the student code is not appealable to the BSEA. Okay, you go to the, you have your principal's hearing, you go to the superintendent, could probably go to the school board, you could go into state court and appeal it through a certiorari process. Manifestation determinations are appealable to the BSEA because they're special education determinations. They're a team decision. the BSEA has jurisdiction over all disputes about special education, and in fact is required by federal law, by IDEA, to have an expedited process. So they have a very quick process for dealing with appeals and manifestation determinations. Essentially, I've never remembered numbers, but I mean, I think you're supposed to have a hearing like within 15 days of filing. And the feds have been very insistent upon compliance with these timetables, and to the extent that they've directed the BSEA. The BSEA has had issues with the Office of Special Education Programming, OSEP, over a number of years about not getting decisions out in a timely fashion in compliance with IDEA. And so OSEP comes in periodically and reviews all their decisions and gives them a grade. They have said you could never postpone, continue, get a different date for an appeal of a manifestation determination. And this guy has gone to kind of ridiculous proportions in that I know of a case in which the student's attorney had a death in her immediate family and couldn't be at the hearing because of having to be at a funeral. And they couldn't just postpone the hearing date. They had to withdraw the hearing and restart the process in order to get some time. Sometimes the law gets ridiculous in the way that it works. But there is a pretty rapid way to get these things resolved. And in fact, I mean, the BSEA recently changed its rules to respond to OSEP's pressure around this. The BSEA used to have another process for getting expedited hearings for other reasons other than discipline stuff, and they've eliminated that. So discipline is the only way to get into this fast track, but they also have an accelerated track for other reasons that they can consider on a case-by-case basis. What you've described, again, for the purposes of the viewers at home, is a complicated situation where, over a course of time, things get kind of worse at the school. Eventually, the child picks up a felony juvenile court charge while there's ongoing special education disciplinary stuff. So the felony 37H1/2 process, 37H1/2 is the statute that refers to it. And what that statute does is it authorizes the school to exclude a student who has a felony charge pending if the principal makes a determination the student's continued presence in the school would be substantially disruptive. So that happens. And you do get a manifestation for that. And so the manifestation is the conduct that led to the criminal charge directly and substantially related to the student's disability. If it's determined that it is, then 37H1/2 can't be applied to exclude the student from school. So it does kind of come back to the special education protection around manifestation. But you're right that, oftentimes, this process kind of goes along and it gets complicated to sort out really what are the issues around FAPE, which should be kind of the underlying driving force of all of this. Which leads me then to kind of answer the general question about how do you prepare for these hearings and what do you do? And I don't have a lot of brilliant insight into this. It's like any other meeting that you go to. The more you know, the better. So you read as much as you can. I mean, if you're new to the case, you get everything you put your hands on. I always send a letter to the school saying, for the general education side, I want everything that the principal is going to rely upon, going to look at as part of the hearing process. I want to make sure that I get all of that in advance of the general education hearing. For some reason, I don't do the same for the manifestation process because I kind of assume by the regulation, I know what's there and I know what to ask for. But if I don't have that, if I don't have the IEPs, the progress reports, the evaluations and things, I want to get that from the school right away and read all that stuff and be able to come in and argue about it. In addition, here's what I think is the most important thing about it. I really think you need to get a professional opinion to help you in these cases, like anything else that we can test. If you want more reading services, you get a professional opinion. You get somebody to write a letter saying it's needed. If you want a one-to-one, you get somebody to write a letter. It's the same thing here. If the kid's got an outside therapist, you get the therapist to write a letter that says, you know, some paragraph that talks about what the background is. I've been seeing this kid for the last 6 months. We see each other on a weekly basis. We're talking about all other things, blah, 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 blah. I understand that he gets discharged. This is my understanding what the charge is. This is my understanding what his disability is. In my professional opinion, his conduct, as described in this charge, is directly and substantially related to his disability. And I bring that in, I put that on the table at the meeting. And if I can, get the therapist to come in and say those things out loud, great. If I'm working with the DCF kid, that's wonderful because I got a social worker, I usually got an ed consultant, I usually have a room full of people to come in. So I get that, I talk to them, I prepare them, and I explain what's going to happen and try and get that out. So those are things I do to prepare and to come in. And the reason I do this is because the law says that it's the parent's burden to prove the direct and substantial relationship, which is interesting because, again, before the law was changed in 2004, it was the opposite. It was the school district's obligation to show that it wasn't. The way it was presumed to have a kid on an IEP, he has a disability, the conduct's related. You didn't have to do anything. You could sit back. Now you have to prove it. So I try and get this information together and bring that in and, again, prepare everybody I can. Pack the meeting, bring people to it, which leads to the kind of final question I think you had on your list. What if there's a disagreement? What if you're in the room and, you've got 3 or 4 people, you've got this student's therapist and the parents there, and you're there, and, maybe there's somebody else on your side, and you're all saying, yeah, there's no question this is directly and substantially related. And the school's got 7 people over there saying it's not. Or more likely what they do is they have a special ed director or the team chair saying it's not, and everybody else sitting tight like that, right? What do? Well, it's no different than any other team decision. Unfortunately, you try and get that to work. Many schools will do a polling rather than get a sense. I mean, they think that this is enough so that they will ask each person what they vote, which is great because then you're more likely to get at least 1 or 2 renegade staff to take the risk of offending the leader. And so if that's not going to, if they're not going in that direction, many times I will ask for that to put people on the spot and to make sure I get their opinion out. But ultimately, it's not a vote. It's not who gets more than 50%. It's the team chair that makes the decision. And if you can't move her, then you're not going to win. So you got to try and, use all of the jujitsu that you've learned in PCTI, to change people's minds. Those Jedi mind tricks, they work great, but that's about all I can say. I mean, it's like any other important team meeting you go to. You go in trying to know more than anybody else at the table, and to use, I have learned over the years it doesn't do me any good to pound my fists on the table. The old flies in the honey kind of stuff probably is true, but I don't hesitate to use leverage when I can use leverage. You've been doing wrong for this kid for so long, and this is a really important place where we are, and let's not make a mistake. And then there's always, I don't know if you get trained in this, but I always like to pull this out of the pocket when I got nothing else, and it's the old least dangerous assumption theory. Let's take the point of view that is least dangerous to the student. Stuff, and sometimes that changes people's minds.
What do you mean by that?
Well, it's just, I don't know what I mean by that. I picked it up probably someplace from some parent or someplace along the line, but essentially, it's to, when we've got to make a decision, let's take the one that is least dangerous to the child, okay? It's going to have the least harmful effect on this child's life. And that's really kind of just a fundamental way of saying, again, let's act in the child's best interest, but sometimes people like hearing it articulated that way.
Can I just ask another question?
Sure.
this is just off my notes, you had said, you talked about a 37.5, and you said it's a felony is a manifestation of disability, but I didn't get what you said after that.
Well, it's just like anything, it's in like any other manifestation. I mean, the team determines it's a manifestation, then the student can't be excluded from school.
Okay, thank you.
Can that student go right back to their original?
That's what the law says. You know, it's a little bit iffy. There haven't been many cases about this at the BSEA. There was one case from a number of years ago, and it wasn't really a challenge about manifestation. The attorney actually had a novel idea about how the statutes worked and was trying to kind of work around the 37.5 exclusion. And the hearing officer kept saying, you know, are you appealing the manifestation? I mean, if you were appealing the manifestation, I'd probably find in your, you know, in the opinion, she says that. But it wasn't. It wasn't appealing the manifestation. It was just saying 37.5 shouldn't be used to exclude students with special education, which is really not the case.
So when the student returns to school, do they need a re-entry meeting, or they just walk in like everyone else? Or does it
Well, schools can have ordinary rules about re-entry meetings and things. And again, I think sometimes that's actually useful.
Okay.
So if they keep the child out of school, is that a violation?
Well, if the team has determined that it's a manifestation, yeah, they can't. I mean, if the team's determined it's a manifestation, the discipline cannot be imposed. The student goes back in.
And they say that they can't?
If the student they can't, then you call a lawyer up and we get an injunction right away. That's easy. Or PRS, you call PRS up, and PRS will call up and yell at them. But you can't keep a student out if there has been a manifestation determination.
What's that manifestation that in undetermined because of?
Well, that's an interesting question. And what if the manifestation determination is undetermined? It can't be. They have to decide it one way or another. You know, sometimes, you know, I mean, if that's the way it's going, I mean, you have to think about your own strategies and tactics. You know, if a team is really on the fence and can't make up their mind, you might want to say, well, let's reconvene in a couple of days and let's get a couple more reports, or let's get another person involved, or, you know, you might find ways to use that extra time to move things your way, but they can't leave it without making the determination.
I think what happens is, you know, when you have a child that's not in an IEP,
Mm-hmm.
then there's that gray area, and I think the school sometimes goes with just the felony charges. So,
Right.
you know, what trumps what?
Well, so if the child, I guess I should have started by saying, you know, who gets a manifestation, and the answer about who gets a manifestation is anyone who's on an IEP, anyone who has a 504 plan, and then there's a third category in the regulations. And you know, we could say the term is students who should be on IEPs, but it's a very narrow should be on IEPs. The regulation says you've got to, essentially, if the parents requested an evaluation and it hasn't happened yet, that child gets the protection, okay? If somebody in the school has, in writing, expressed concern about a pattern of the student's behavior, that student gets manifestation protections. But you know, I've never figured out how I ever figured out if that's happened. You know, I mean, why, you know, kind of thing. But at any rate, those are the kind of narrow categories. So, you know, the kid who doesn't have an IEP, who hasn't been into that process where if there isn't any consent, does not get a manifestation meeting, you know, that's it. And so they just, their 37H1/2 hearing is the principal determining whether or not the continued presence of the school will be disruptive. And I got to tell you, you know, out of all the ones, those hearings I've done, I think I've won one of those and convinced the principal that the student wouldn't be. I try a lot of things to keep the kid in school. You know, I offer, you know, you can search the kid every day. We'll have check-ins. We'll do this. Here's the kid's minister. Here's the kid's football coach. Here's the, you know, the kid's grandparent. you know, Santa Claus likes this kid. You know, I pull it all out to try and keep the kid in, but, you know, they, you know, and this just substantially disrupting. I mean, you know, schools, you know, can do this easily. I mean, like if there's been a fight, you know, they'll say, well, if we let this kid back in, the victim has friends in the school, will beat the kid up. And so that'll cause a disruption. So we can't let him back in. It'll be substantially disruptive. If it's drugs offense, I mean, you know, the kid, you know, sold a bag of pot to somebody downtown, not at school, whatever. You know, why should that kid be excluded from school? Oh, we have a terrible drug problem at our school. It'll be ineffective on the drug problem. You know, they find a lot of ways. I mean, the ultimate case about this is not a good case factually, but I'll just throw it out there. So there's a kid that is on an IEP, picks up a criminal charge for sexually assaulting a minor, not at school, you know, but, you know, it's a bad thing. School doesn't know about it for 6 months. He continues going to school, Then finally, somehow the school learns about it and says, we're going to exclude you, 37H and a half. And so this kid's lawyer says, well, principal, you got to show me how this kid's presence is going to be substantially disruptive. That's the standard, okay? You know, the kid's been in school, he's not been a problem, whatever. And the principal says, you know, that's my decision. So he's excluded. They appeal it to Superior Court. The Superior Court judge says, you know, principal, you got to show me there's a connection between the crime and, you know, this kid's presence in school, that there's something, you know, I mean, if you ran a nursery in the school or, you know, what, you know, childcare or something, it'd be different, but it's high school, you know. The school appeals to Superior Court judge. Superior Court judge says, you know, it doesn't meet the standard, goes to school. School appeals it, and it goes to the appeals court, and the appeals court says, let the principal decide. As long as he thinks that it's necessary, that, you know, we're not going to overrule it. So you're not going to win too many of those cases, but it's always worth trying. But the important thing here, and this should be probably the end stuff, the best thing about IDEA is there's never a cessation of services. So even if it's you lose the manifestation, the school's going to exclude the student for 90 days. They have to continue to provide the IEP services to the student in some format, okay? That's the beauty of special education. Now, it's not so important anymore because we've got this nice new law in the state that says the school's got to continue to provide educational alternatives for everybody. So nobody's just out of school. There's got to be something else going on. Now, there's something else going on for non-special education students. Can be rather minimal things like tutoring or online schooling or Saturday schooling or other things. For the kid with special education needs, they get the services on the IEP. They get something close to FAPE. They don't really get FAPE anymore, okay? But they get something close to FAPE during that period of time. So, you know, if the student's been getting speech language therapy and they're out for 90 days and the school's doing tutoring, in addition to the ordinary tutoring for their classes, they better be getting that speech language therapy. So that's the, you know, the good thing is that we fight these fights about manifestation, but ultimately, you know, we're going to be able to keep the students going. And that's kind of, again, a cardinal principle of special education law. You know, federal special education law came out of a bunch of hearings that Congress held back in the 70s. And one of the determinations that they made was that at that time, there were 6 million students with disabilities who were being excluded from school for conduct related to their disabilities. And Congress says that's got to end. And that's why we've had this no cessation of services as a fundamental principle of IDEA ever since its beginning.
That is a great place to end.
Yeah,
Thank
exactly.
you so much.
Thank you.